Yeah, so it's a good time to make a start now. It's 4 p.m. right now. Welcome everyone. My name is Alex from LexisNexis, and I will be your host and MC for today. We're very happy to have Mr. Alfred Ip, a partner of Hugill and Ip Solicitors, as well as Mr. Azan Marwah, Barrister-at-law and mediator from Gilt Chambers today, to conduct this family law knowledge sharing session with us. The topic will be on how to protect your children in cases of divorce. Now, before I pass the floor over to them, I just want to let you guys know that our LexisNexis Hong Kong account will be momentarily shooting out a message to you guys. It will include a link which will bring you to an internet page where you can give us feedback on future topics on this particular session in particular. So we really appreciate your feedback. So if you do have the time to click on the link and give us feedback at the end, we would be happy if you could do so. And finally, when it comes to questions to Q&A and things like that, you can please feel free to send a direct message to Alfred and Azan, or you can send it to the LexisNexis Hong Kong account, and then we can, towards the end of the session, we can read out the questions for Alfred and Azan. Or of course, at the very end, if you're inclined to turn on your microphone and ask the questions directly, feel free to do so as well. So without further ado, please welcome Alfred and Azan. Thank you.
Thank you, Alex. Hi, Azan.
Hi.
Before we start the topic, perhaps we can share about how come we have this idea of the topics today. I believe that children are often the center of attention when we are talking about divorce, in particularly when the client first come to us, telling us about their differences with their other half. One of the major issues that we touch upon is the children. What's going to happen to the children? And that is the reason why we often spend a lot of time on it. And is it very common for children this to become very contentious in court?
Thanks. I have to say, first of all, thanks for asking me to join you here, Alfred. And I totally agree with you that in fact, it's maybe the first question that I ask people when they first come to me for advice, whether it's friends or professionally to clients, because the case involved children. The reason why is that legally, the existence of children and the divorce, particularly divorce, but generally in relationship breakdown, completely changes how a case will proceed. And you're quite right to say that very often children can become, it's very lamentable, children can become the major source of conflict, or the focus of the parties' conflicts. And it's rather unfortunate because on the one hand, divorce is exactly when children need you the most. That's when they need their parents to be looking after them, after their interests. And it's also the time when, therefore, it's the time when parents really need to be able to communicate with one another to protect children. But it's exactly the time when relationships are breaking down that communication is also breaking down.
Yes.
And coordination breaks down, and that's when it can be easy to overlook the children's interests, which isn't necessarily going to be the same as the party's interests.
A lot of time, couples, when they're coming to divorce, they will say, I want to keep my children, they're mine. They're not, I don't want him to have it. I cannot let him have it. Yeah. It's actually very wrong.
Yeah, I think that most of the time that impulse, it comes from a completely understandable, very human position. But most of the time, it is not the thing that is in the children's interest. In fact, I might put it a little bit differently. The way, I'm not a psychologist, but the psychology that I've often seen in court, and I try to understand, I try to empathize and sympathize with the clients, whether my client or the other client, to see their position. And I think most of the time the way they think about it is more, I need to protect my children, and I am the best person to protect my children. So very often they confuse protecting themselves with protecting the children, because they think that the other person is the enemy. And sometimes they are, right? Sometimes that is true. but you often miss that the children might have a different perspective, they might have a different need, and perhaps your battle mentality with your spouse or your partner, that's not really the mentality that the children need you to have. They need you to be cooperative. Yeah, it's very natural though. It doesn't happen all the time. And even in cases where people are still able to communicate with one another, you still need to be able to navigate through, because in my experience, and I'm sure this is your experience too, communication doesn't improve. It deteriorates.
It deteriorates a lot of time.
And even if people start off being able to talk with one another, as litigation proceeds, there's a lot more distrust gets built up.
Yeah.
And in the courts, it's certainly true. The courts try to make sure that children's issues are dealt with early, both because they're the most important issues, but also because they don't get easier to deal with as time goes by.
Yeah. But then, this is actually the time when we as solicitors often spend hours writing pages of correspondence among lawyers talking about children custody and assets. And in my experience, actually, the concept of custody is getting more and more common, accepted among the divorced parties, in the sense that they don't really see custody as the children become mine or his or the other side. They understand the concept of shared custody. Can you explain a little bit about shared custody?
Sure. So if I can maybe, I'm very grateful that you've put up the relevant slide.
Yeah.
The word custody is an archaic one. It exists in the law, but it's an archaic concept, and it has in fact, it can be used in different ways. Custody historically means the power and possession over the child, making all the decisions, having the care, control, everything that a parent has over a child.
Yeah.
Now, as the law has developed, the way that we understand custody, the reason why it exists, these rights exist, is actually not for the benefit of the parent. Like the child is not a toy or an asset, but it's not. The child is not a thing. The child is a person, and the power that you have over the child exists for the child's benefit, not for your benefit. And so actually the power you have over the child is proportional to what the child needs.
Okay.
If the child doesn't need you to have power, then actually you have less power.
Okay.
Now, within custody, now when parties are married, both of them share custody.
Yes.
In fact, you can say that both of them can act independently. So let's imagine, God forbid, that you should have a child and the child should be injured in an accident and should be taken to the hospital. And a decision needs to be taken about whether or not the child should have an operation. Even if only one parent is there, even though they have joint or shared custody, that parent is empowered to make the decision.
Okay.
Now, if you think about it is there a question? If you think about it in the normal way, if parents who get on, who are in the middle of a divorce, they try to make decisions together. And the law expects you to make decisions together.
Why? They're divorced.
But before we get to divorce, the starting point is parents normally have these powers separately, but also together.
Okay.
And they're supposed to talk with each other. They're supposed to discuss, but at the same time, they can act independently. Now, the question is, how should all those powers be assigned when the parties are getting divorced, when they can no longer cooperate effectively together?
Exactly.
So the concept, the sort of basic standard concept, is something called joint custody.
Okay.
And joint custody is, well, the situation before the divorce, as far as those big decisions, should continue after the divorce.
Okay.
Because in a sense, why should anything change with those big decisions? You're still both parents of a child. You still have the same responsibility towards the child. Like I said, that relationship between rights and responsibilities is a very strong one.
Okay.
And so the idea is that in most cases, you should be able to continue to co-parent.
Okay.
Now, in barring special circumstances when parents cannot co-parent, they cannot negotiate between themselves to make those decisions without fighting, without making, have the operation, don't have the operation, without contradicting each other.
Okay.
That's when the court might need to step in and say one person should be exercising sole custody.
Okay.
Now, we've been talking a lot about custody, but as you can see from the slide, we draw a distinction between this concept of, if you go back to the previous slide there, Alex, sorry, the previous slide. Yeah.
Yes.
There's a distinct, custody has different parts.
Mm-hmm.
And the two big parts of it are custody and big C custody.
Yeah.
And this other concept of care and control.
Mm-hmm.
The big C custody is making those big decisions.
Okay.
Which school, what religion, which
Yeah.
operation, you know, the big lifetime decisions.
Mm-hmm.
And care and control is the day-to-day responsibility. But in a technical sense, both of them are part of custody.
Mm-hmm.
Now, the courts recognize, and now you can go to the next slide before we come back to what happens after marriage. Sorry, to the next slide, to slide 5.
Very good.
Yeah, great. So the courts are divided up a few different options. For the big C custody, there's this joint custody, which we were discussing, sole custody. And in the case of a disagreement, the court might decide one of them or both of them, or they share. Care and control, similarly, can be shared between the parties. It can be joint, so the court doesn't even need to say you're exercising it sometimes, you're exercising it others. Joint care and control is basically like the situation before divorce. You're both sharing day-to-day responsibility. And that might be more popular if there's a more fluid relationship between the parents to the child. Maybe the parents live next door to each other. Maybe they have a very close relationship and everyone is still friends. Shared care and control is where the child is spending defined periods with one parent or another. And when the child is with you, you have responsibility for that child. So in a sense, the care and control is with you when the child is with you. But when the child isn't with you, the care and control is with the other parent. And sometimes the courts won't give custody or care and control to a parent. And you can imagine why. Some parents are not capable of taking on those responsibilities. And in some cases, the courts will give only an access order. They might give the other two orders and they will define access. Access is basically the time you spend with the child. So if we can go back to the previous slide. Sorry, Alex. So after, as you can see, after a divorce, the court has to consider, what am I going to give to each parent? And most parties will think of it, you're quite right, in the previously, the sort of pre-modern approach to it was to think, this is mine or yours, zero sum. But the courts, and I think the parties are quite right, they're changing their attitude, and it's right because it's more focused on the child. What does the child need? And most of the time, the child needs both parents. So the courts are more focused on shared care and control, joint custody, and defining, having specific orders where there's a real disagreement and the parties just cannot decide between them.
And would it be right to say that if the parties can cooperate with each other, coordinate better, and co-parent together, there's a higher chance that they will get shared custody or shared care and control?
Yes. And conversely, when they really can't get on well with each other, then there's more of a chance for these defined, delineated roles. But I can say that these days, the family court in particular is very strongly in favor of joint custody. Because normally it may be that one parent is more suitable to take the child to school, to get the child ready in the morning. Let's say one parent travels a lot, the other one doesn't. But for custody, those big decisions, the courts expect people will have time to have a discussion. And they will be able to, even if it is not in person, even if you're not able to, like you and I are having a very pleasant conversation. But if we didn't get on very well, we could do it by email, we could do it by telephone.
WhatsApp nowadays.
Exactly. So the courts are increasingly expecting people, particularly people who can focus on the child's best interest, to be able to do it in conversation, cooperatively.
But a lot of time parties have different opinion about the children, especially the way that they are brought up or whether they should do particular thing at a certain time. For example, soccer lesson versus swimming lesson. That's when they cannot cooperate with each other, and probably that's the reason why.
Well, I would say that that's true. That those are exactly the kinds of things where parties fall down and are not able to agree. But when that's really the case and parties can't agree, that's when it's time to consider going to court. But I will say this: the courts have little patience for petty bickering, and the cost of going to court can often be such that it just makes more sense to have a discussion. Agree maybe piano lessons one week, swimming lessons the other, or soccer practice the next week. And I think that, and then we will. I think can you go to the next slide? Sorry, you can see. The concept here is the best interest, the welfare of the child. And the way that the court examines what that means, as time goes by, the child is going to have more say. Maybe your child wants to go swimming more, or wants to play soccer, or wants to learn the piano, or whatever. And that will more and more have weight in deciding what is the right thing to do. Look, I would say that whether or not the court orders joint custody or sole custody or joint care and control will more depend on whether a party is able and willing to act in the child's best interest. If a party is not able or willing to do so, that's when the courts are going to be more likely to give one party more control over a particular set of decisions.
But how would the court know, especially when you're talking about a judge who never met the parties, who never seen them, who don't know how the children are going on, how they're arranged at the moment? How can the court decide?
Well, maybe you can go to the next slide. I've tried to set this out very briefly without getting into too much of the weeds. So in a divorce case, in a contested case that comes in front of the courts, there are a few avenues that the courts use to gain information to make the decision. And the first one is there's a form called the Form J, which is basically like a questionnaire, which is filled out by both parents, where they fill out the details relating to the care of the child. And so that's like the first stop. How old is the child? What school does the child go to? Where does the child live? Those kinds of specific details. And then the courts also use something called social welfare reports. So the court is empowered when considering what's in the best interest of the child to hear information from a social worker employed by the social welfare department. And they will go along and they will act as the of the court, meeting the child, going to the child's school, going to the child's home, collecting information and describing it to the judge.
I'm pausing here because it's obviously these two documents are extremely important when a party wants to get more control or what they decide to resolve in relation to custody or care and control. So the Form J, first of all, has to be very detailed. And setting out how the children are looked after in terms of their breakfast, going to school, what sort of extracurricular.
I don't know about breakfast, but I mean maybe, but
because I mean there's often this form a basis for the social welfare officer to do their homework before paying their visit.
That's right. The Form J can be very important in raising what the issues are. The other way for the issues to be raised is in the interview with the parents. But the problem with that is that then you might end up surprising the social welfare officer. They might mishear you. They might misunderstand, and then you end up with a social welfare report that doesn't cover a key issue. So I quite agree with you. The Form J is critically important in gathering that preliminary information, kind of highlighting what the key issues are. The worst thing is for an issue to be raised at the last minute and there not to be proper evidence, proper information available to the judge. Because then, as you say, how can the judge make the decision?
And preparing for the interview by the social welfare officer can be quite daunting, according to some of our clients' experience.
I entirely agree in that it can make or break a case. There are some judges who are very independent streak and really look critically at social welfare reports and maybe ask very critical questions of the social welfare officer. But in most cases, most of the judges are really very reliant on the social welfare officer.
But why is it reliance on them?
Because the judge can't do the things that we were discussing. It can't go along to the school, can't go along to the home. Don't want to. It's not for the judge to get down into the woods. But I guess at the end of the day, because the law says so, there is a law that says that these reports are going to be prepared and that the judges must consider them.
And I suppose social welfare officer has no reason to be biased towards any party.
Well,
they're supposed to be impartial, but is it the case?
They're supposed to be, I wouldn't say they're supposed to be impartial. They're supposed to be partial towards the children.
Okay.
So, but you're quite right to say we all have our biases. Mm-hmm. There are social welfare officers who don't like pets, don't like dogs, don't like cats. Mm-hmm. I've heard clients complain that the social welfare officer came into their home, saw they had a dog, and freaked out, and throughout the rest of the interview just had a very hostile attitude. So I mean, it can be something as silly as that. But sometimes they may have a bias towards the father, bias towards the mother, bias against this, bias against that. I'm sure that all social welfare officers are trying their best, but the truth is everyone has their biases. Mm-hmm. And knowing as much as you can up front and putting on, if you like, your Sunday best for that interview is very important, because it really can be make or break in terms of the final order. You don't want to, now it's not about pulling the wool over the court's eyes, in fact it's the opposite. You really want to be prepared so that the court knows everything, knows it properly, and doesn't know it from a skewed end.
Let's say that I screwed up in the social officer's interview, and the recommendation is not entirely in my favor. Is there any recourse for me?
Yeah, it's not the end of the world. The social welfare officer is not the judge.
Okay.
And the judge is supposed to make an independent decision. And I have several times challenged the social welfare report and got a judgment which completely disagreed with what the social welfare officer said. So it does happen, and the law is that the court must consider the report, not that the court must follow the report.
Okay.
But it really depends on what the issue is. And it's also not impossible to raise issues about the interview or raise issues about how the social welfare officer conducted themselves to persuade the court to order a new report. That's possible.
Okay. But obviously, if that is the case, that means we have to get direction in order to get another social welfare report. That means more hearing,
more delay,
and more cost,
and more anxiety. And it can be quite contested if one party has a report in their favor, whatever that means, and then is struck by an application to have that set aside. It can make things worse. It's also not impossible. It's certainly possible to get an independent social workers report. That has happened. It's a little bit more common in England than in Hong Kong. In some cases in Hong Kong, when we have Hong Kong is an international city, that's certainly true. And it's not uncommon to have an international social workers report from ISS or from a local or a foreign social worker. So it really depends. It really depends on the issues.
Okay. So if the parties cannot agree among themselves about custody, care and control, and access arrangement, is there any other ways that they can resolve it apart from the court proceedings?
Yeah, I highly recommend in all cases that parties look at mediation. That there are two, what we call ADR, alternative dispute resolution. There are two standard approaches. One of them is private mediation. In Hong Kong, there are many options, from the very expensive to the very cheap. From legally qualified media like myself to social workers and even priests, accountants who are social workers or mediation trained. You can find someone who fits the parties culturally, socially, linguistically. That is one of the best ways, because the mediation is non-confrontational. It can be, particularly child-focused mediation. It can be fixed on what's in the child's best interest, and it doesn't involve what you were describing earlier, the inter-solicitor correspondence. Because it's certainly true what you were saying earlier. Solicitors, present company accepted, tend to draft for the court, draft for the worst case scenario, and parties, when they read it, they think this letter is coming not from Hugill Ip, but from the husband, from the wife. And so when they read it, they think, why is she saying this? Why is he saying that? Why is she suddenly so defensive? Yeah, exactly. And even something that should be read with a cool head, reasonable head, but can easily, in the context of divorce, be read as a personal affront. And so mediation is good because you can change the way in which the communication is done. Now, I personally recommend mediation supported by your solicitors, particularly solicitors who are focused on achieving a non-confrontational result. But mediation can also be good in that it can put the parties in the same room, on the same level, talking directly to the mediator, and not being about my rights, what's owed to me, and more be about solutions. How are we going to get through this in an acceptable, mutually acceptable way? The second way is, and I'm sure you know, the child dispute resolution, which is a kind of alternative dispute resolution where a case can go in front of the judge, and the judge can be asked to give an indicative ruling. So they don't decide the question, not at that hearing, but they give you like an indication. Like, look, I haven't heard the evidence, I haven't heard the witnesses, but I've reviewed the paperwork, I've seen the affidavits, and I will probably decide this way. I will probably do that. Or if there's a dispute between the parties on some narrow issue, the court might say, well, this is what I think the law is. And sometimes I can close the gap. You know, in Hong Kong, the child dispute resolution hearing is normally conducted by the judge who will hear the trial. So it's a little bit, it's very different from a mediation. But it's another way that you can, if you like, avoid a full-scale trial.
But how different is it, the CDR compared with the trial in terms of process or in terms of the outcome?
Well, the CDR, well, let's first go through trial. A trial is focused on specific issues. The parties will seek particular orders from the judge, and they will have fixed positions and will be trying to get at those particular positions. They will say to the judge, make an order in this form. And they will take turns presenting and challenging evidence. Now, when I say that, it means, as you know, having witnesses. So normally the husband, the father, the wife, the mother, giving evidence and having questions put to them. Cross-examination. It's very confrontational. It can be very acrimonious. It takes a long time. It can take days, and sometimes it can even take weeks to finish a trial if there are many witnesses and a lot of evidence. And it can take a long time to get to the final result. The judgment may take 3 months, 6 months, sometimes even longer than that. And parties don't get to be closer friends at the end of the trial.
Actually, I always say that when you're going through trial, everything that you have done will be
under the microscope.
Under this microscope and expanded unnecessarily. You've said once the wrong word, and then you have to defend yourself. And you become so stressful, as if you're the worst person in the world.
You called her the B word in front of the child. You called him the D word in front of the child.
You use the F word.
And things which can be forgiven can be looked to the side. You will have them put to you. And in most of the cases, they may not be definitive. But the process is one which is very taxing and results in parties who are further apart. And judges don't want cases to go to trial. Partly for their own, definitely also because of the children. It's if you put parents through the trial, in a way you're putting the children through it too. Now the difference is between that and the CDRs. CDR is about coming to an agreement. And now an agreement can, once it's reached, that's the end. No more appeals, no more debate, no more waiting for judgment. It is what you agreed to. You can also participate in the agreement, like in mediation. You can say, well, I will agree to what you're asking for, but I want this, and why don't we do this, and why don't we compromise a little? In a trial, there's no compromise. There's only the judgment. The other thing that's beneficial is it doesn't take or have nearly as much effort required. Normally, it takes half a day or a day. I've seen some CDRs which have taken more than 1 day, but giving parties the chance to negotiate and discuss. They don't involve cross-examination. They don't involve these fine, minute details coming out. It's more about what's a workable solution.
Focus on the solution instead of who's right and who's wrong.
That's right.
So this is the major difference, I believe, and I hope that eventually parties can take advantage of the OCDR proceedings, which is designed to help parties come into a compromise and get on with the next phase of their life that is after divorce.
Exactly.
Yeah, that is for the divorce. It is totally understandable. But is there any difference when the parents are not married?
Yeah. So the law is different and in some ways the same. So the first thing to say, the most important thing to say is that the guiding concept, the paramount consideration is still the best interest of children.
Okay.
So whether you're married or unmarried, that's what you need to remember. That when the court has to make a decision, it's that same test, that same consideration.
Okay.
But there are important differences. So focusing on child custody, when the parties are unmarried, the children who are born out of wedlock, the default position is different.
Okay.
So earlier when we were discussing, and I said that when parties are married and they have children, they have joint custody.
Yeah.
But the starting point for unmarried parents is that the mother has sole custody.
The father doesn't.
And the father has nothing.
Oh.
Nothing.
Really?
Yes.
Oh, that's. I'm sure a lot of people find it very surprising.
Yeah.
The father has no right.
So in this respect, Hong Kong is diverging, or the other countries are diverging from Hong Kong. Now there are some good reasons for that, and there are some bad reasons for that.
Okay.
But at the end of the day, it is what it is. Now, when I say it's the default, that means that basically from the moment the child is born, the mother is the mother.
Okay.
And has the legal rights of the mother.
Okay.
And the father has nothing.
Yeah.
But as soon as the father wants to obtain those rights, all he needs to do is go to the court and apply.
For guardianship order.
Exactly. Now, the court has to be asked for what the father wants. So the father will have to say, I want joint custody.
Yeah.
I want sole custody. I want access. I want care. Whatever the father wants. And the approach of the court will be the same. There will be no presumption that the mother will get everything.
Okay.
It will, in the same way that divorcements, there's no such presumption. But the starting point is different, and you have to make the application in order to get anything.
Yeah.
Yeah. So, for example, I mean, we'll talk about this a little bit later, I think, but if there's an unmarried couple and the mother, even if they've been living together and raising the child together, and if the mother one day decides, I want to leave and go to Australia, England, wherever, she has full custody. She can do that like that.
So the father cannot stop her.
Well, the mother can stop her.
Okay.
But if the parties were married, a mother wouldn't be able to just do that. The father would already have custody, and he would be entitled to participate in that decision.
Okay.
And he could object to it. Now, for an unmarried father to object to it, the unmarried father needs to, as quickly as possible, go to the court and say, I object.
Okay.
And I want parental rights, and I don't want the child to leave Hong Kong.
Okay, which goes very convenient to our next topic, that is the removal and the relocation.
Great.
Yes. So, a lot of time, a lot of parents have a concern over whether the other party, especially the one who's looking after main carer of the children, will simply uproot themselves and move back to their country, where they're from, or they need to abscond, get away from the father. What would be the usual advice? You usually tell them stop him at the immigration.
Well, the first thing is to say that's not uncommon at all. It happens quite frequently. I've done many cases or applications to relocate, and also non-removal applications or return applications. It's very common, particularly in a place like Hong Kong, as we were saying, an international city. Yeah. And people tend to have another place to go.
Yes.
Which in some places wouldn't be possible. In Hong Kong, there's always some, well, not always.
In the past.
There's always
some COVID.
Yeah, exactly. And COVID has certainly brought up a number of very interesting issues.
Yes.
But what my first piece of advice to say is, if you are concerned about an imminent risk, you can and should go and apply to the court for a non-removal order. Okay. Now, you can actually get that order pretty much immediately. Okay. You only go and register something with the court. Yeah. You don't even need to have a hearing to stop to prevent a removal from the court. Okay. And really, it's a question about how quickly you can get that piece of paper communicated to the immigration. and immigration should stop. They have quite a well-oiled machine to stop children from being removed. Now, my other piece of advice will be to say, what passports does the child have? Do you have the numbers? Is the name spelled correctly? Because at the end of the day, the immigration will all be about what the name, the information they have in front of them. If there is a John Wong with an American passport and a John Wong with an Australian passport, or Hong Kong SAR or whatever, and you only give them one of them, and the mother or the father has chosen to use the other one, well, then you're out of luck. So my first piece of advice would say, how realistic is that? If there's a real risk of that, you should take steps immediately.
So the question would be, do you know where your children's passports are?
Yeah, but again, I have seen cases where parties have forged signatures to apply for new passports.
Oh yes.
It's not the end. It's not just because you have the physical passport can be very important.
Yeah.
But yeah, I would go to immigration and I would be making that application, communicating it to the Director of Immigration. Now, unfortunately, that should be done before time. Not right before mom goes on holiday.
Yeah.
Or right before dad goes on holiday.
Yes.
That kind of aggressive step can really deteriorate the relationship.
Absolutely.
And send the wrong message. And you want to be, if you're concerned about that, you want to be taking steps ahead of time, not at the last minute, because that can lead to, I've seen children disappear for 3 years. And, I've seen really, really terrible circumstances. You want to do it well before time to prevent it from happening.
Yeah.
And you want to do it in a way that's not going to lead to more fights, more conflict. You want to make sure that it's done in a protected way, not in a way which is combative.
Look, the client should know, though, if they are in a very, very bad situation with their spouse, and suddenly the spouse says, "Oh, I want to take the children with me for holidays," they should smell something.
So, sometimes they do, but often they don't. I've had a client who wakes up one morning and everyone's disappeared and they have no idea. But it can happen.
Pack everything and leave.
I would say if you're having difficulties in your relationship, and your wife or your husband or your better half has communicated to you that they have some real concerns.
Yeah.
They may have trouble raising to you the big question. But you should be attuned to, hey, there's a big problem here, and you should be communicating with them as much as possible.
Yeah.
But very often, this is why people get divorced. Their communication deteriorates to the point where they're not really paying attention to those things.
But what if it really happened? So they pack everything and leave in the country. What should the father do?
Okay, so the father should first take legal advice.
Yeah.
Because it is a legal issue. And in many countries that Hong Kong has if you like, large social connections with, there are things that could be done to bring a child back.
Which is Hague Convention.
Yeah, so there are basically two categories of cases, Hague cases and non-Hague cases.
Okay.
The non-Hague cases are basically a mirror of the Hague cases. We'll just talk about the Hague cases.
Okay.
There is a convention, so an international treaty between different jurisdictions that covers Hong Kong that provides for children to be returned if they're what we call abducted.
Okay.
So a parent who takes a child in breach of the custody rights of another parent is abducting the child. No, that's a better word if you like than kidnapping or stealing. With that, we call that abducting.
Okay.
And then when that happens, this statute, this treaty exists because the idea was, well, that's not good for the child.
Yeah.
If there's a dispute, a genuine dispute about where a child should live, that should be dealt with in the place where the child is, not in a third country far away.
Absolutely.
It should be dealt with before the child moves and not afterwards.
Yeah.
So it was decided between all these countries and jurisdictions that the best interest of the child, so that's back to that best interest principle, was that the child should be returned immediately.
Okay.
And the decision can be made in the home country.
Okay.
So what you do is, in Hong Kong, if a child was abducted, you would be saying you need to go to the Department of Justice.
Okay.
if the child had been taken to Australia, UK, Canada, one of these countries which is within Hague.
Okay.
And you'd say, please, the child was abducted and I need your help to get the child to be returned. You would want to provide full information about the child.
Okay.
And they can secure a return of the child.
Okay.
But what they do is they would go to that third jurisdiction and they would make an application in the court there. And the court should, within 6 weeks, return the child after the application is made. And Hong Kong has a reciprocal arrangement. So if you are in another jurisdiction and the child is abducted to Hong Kong, then you go in front of their DOJ will come to our DOJ, and our DOJ will apply in court. And within 6 weeks, there should be a decision from the judge.
How about the non-Hague countries? Are they different, very different?
In a sense, it's procedurally different. But it's in front of the same judges, in the same court, and there's a similar set of principles. So there's best interests principles. There are slightly different rules, but it's basically the same thing. We call it wardship. So you go to the High Court, and you say to the High Court, you might not have as much assistance from the Department of Justice. That's a major difference. But you go to the High Court and you say the child should be returned. And the court should deal with it in a very similar way, quickly and on the basis that the best interests require the decision to be taken in the home country.
So in the worst case scenario, don't panic. Go to the lawyer and then go to DOJ, make an application, hoping that the children will return to you as soon as possible. That will be dealt with within 6 weeks.
Yeah, I entirely agree. I would just add one thing. Don't panic, but act expeditiously.
Don't sit there.
Don't sit there, because both in wardship and in Hague, the court has a principle that if you sit on your hands, they're not going to help you. So there's a period of time after which the child's interest will not be to, every year move back and forth between countries. So the judges, the courts, the law expects you to act expeditiously.
And if you can, you wouldn't sit and wait.
Although,
so find a solution. And in terms of relocation, one last thing. If the mother, for example, wants to move back to the country, how can she satisfy the court and get the relocation order?
So there's an application that can be made if the parties are divorced. So you can do it through the family court, you can do it through the High Court, and the court will essentially you can go through the CDR procedure. That is there. You can do mediation, all these things. So whether the parties are in divorce or before divorce or after divorce, or married or unmarried, but with joint custody, the court can and will hear the application. When the court hears the application, the principle is still what is in the best interest of the child. I put there in the slide, you can see it, the way that the court considers it. It's still about the best interest of the child, but there is a nuance there that the court will consider. One, are you making the application for a good reason? Not in order to get rid of the husband or the father or the wife, or the mother, because you need to move or you want to move. The second thing is have you made suitable plans? You say you want to move to Australia, but do you have a visa to go to Australia? Where will you live in Australia? What will you do in Australia? The third thing will be how will it affect the child? And how will it affect the other parent? And is their opposition motivated by the child's interests, or is it motivated by their own selfish concerns? Again, the focus is really on the best interest of the child, but measured against the interests of the parents. The parents, their interest does come into it, but the child's interest is still the paramount consideration.
I will only add that in order to convince the court it's the best interest for the child, you have to have a very detailed plan.
That's very, very important.
You have to think it through. About to find a secure space for the child, knows that who is going to be paying for the school fees, and whether if the other side is the financial supporter, he or she has the means to pay for the school fees, which goes to the maintenance of the children.
Correct.
And in that respect, we were talking about father have no right to the child when he's not married to the mother, but he has duty.
Well, in fact, this is that principle we talked about at the beginning.
Mm-hmm.
The rights and responsibilities are proportionate to one another. So actually, the law, an unmarried father of a child born out of wedlock, I say unmarried to the mother.
Yeah.
The father has no duties to the child.
Not
no
even
rights
payment?
And no duties.
Okay.
Unless and until the mother applies.
Ah.
Or the guardian. I mean, it depends. So sometimes children, the mother is gone or dead or God forbid, but something like that. The principle is that basically the father is a stranger to the child until you go to the court. Now, in fact, I'm doing one of these applications very soon.
Yeah.
And you basically go to the court and you say to the court, this person is the father. So the first issue is that person actually the father?
Yeah.
If they are the father, can they afford to pay? How much can they afford to pay? How much does the child need? And is it a fair thing that they would be asked to pay? And that's very similar to what you do in divorce, which is, again, what does the child need and what do the parents have and what's fair for the child to pay, or for the father to pay?
And in that respect, actually, we do have a lot of questions in relation to what is affordable, what is reasonable. Yeah, a lot of time, especially when the parents are in the fight, they will have different opinion about whether it is necessary for a certain expenses to be incurred. So a lot of time we are thinking, how can we eliminate those kind of dispute? For example, school fees. If a typical family with the father being the breadwinner and mother being the caretaker, then it's almost natural for the father to be responsible for the school fees. But what if they have a different opinion about extracurricular activities, whether the children need new uniform every year and things like that?
I suspect on the uniform, well, the first thing is to ask, is it material? Uniform costs are unlikely to be substantial. Some cases perhaps, but unlikely to be that substantial. And so something like a new uniform every year, you're probably going to lose that if you're objecting to a new uniform. But other things, you're quite right to say they can be a source of real conflict. And conflict on two different angles. One thing is, does the child need to have every minute of the day booked out with this activity or that activity? And that's really a welfare concern. The second one is, you're right, is cost. And the courts look at it in the context of what the parties can afford, but also in the context of the standard of living. So well, what did the parents have? What did they plan before the breakdown in the relationship? What is the expectation? And so the court kind of looks at you, looks at your background, looks at the way that you conducted yourself before the dispute, and tries to decide what is fair. So it's what's in the best interest. That's what's fair.
And perhaps in that case, in that situation, we should go into a little bit about the Form E, which is very common form that is exchanged among the parties to set out the four aspects. I will always call it the four aspects: assets, liabilities, income, and expenses. It's 20 pages, it's very comprehensive, but a lot of time what I see is that the parties have not been using the opportunity in the Form E to set out in details in terms of their living standard, what they expect from the court, because if we are only filling in the figures, it doesn't give you give the court a lot of insight about the living level that, and don't put the court into context of how the children have been looked after.
So from a technical point of view, as a lawyer, the Form E is a special document because it is both evidence that you're telling the court these are the facts. But it's also pleading. So you're telling the court, this is what I want. This is what I say. And it's a kind. I totally agree with you. It's a document that is really not given enough thought and not prepared fully enough. And really, it's the kind of document you really need legal assistance to do it properly. I totally agree with you.
I think we can spend another hours on the finance part. But since that we have been prompted that there are only 5 minutes left, perhaps we can spend a little bit of time on domestic violence. That is, when your children misbehave.
No. You're terrible.
Well, you know what? Children sometimes, they shout, they talk back.
In my experience, it's more the parents who misbehave. But I'm so glad that you raised this topic. It's the not for us. It's really in those extreme cases where protecting children isn't only about avoiding the toxic stress of divorce or providing for the school and all that. It's where there are real threats to children. Now on this I make a few points to put here.
Yeah.
The first one is to say that it is not as uncommon or unusual as you think, unfortunately, in Hong Kong. And it is the kind of thing that is exacerbated by the stress of this kind of interrelationship conflict.
Yeah.
The second thing I'll say is that you have to open your mind a little bit about what constitutes domestic violence and abuse. I put down there a few different broad categories, but one thing I would add to that is that children seeing violence, witnessing violence and conflict is its own kind of violence to the child.
Okay.
I mean, I'm sure being a solicitor, you'll have seen plenty of circumstances where people yell at each other, violently, if not physically violently, in other ways violently in front of you. And even if you're not having it directed at you, being in that room can be very stressful.
Oh yes, absolutely.
And children are, particularly children going through divorce, but they don't have the full support of their parents, can be especially susceptible to that kind of stress and psychological violence of being surrounded by abuse. Yeah, but sorry.
So it's not confined to parents abusing the children, either physically, directly, or emotionally, but actually abusing each other can be a form of abuse to the children.
Correct. Yes, definitely.
And in that respect, how can the victim protect themselves?
Well, I mean, we're talking about children, so we're talking about a category of people who need us to protect them.
Yeah, let's say our client is actually subject to it's actually happened a lot of time that they say we might use hands, we might use punch to each other, but he never hit the children.
Yeah. Well, as we just discussed, that does not mean the children are not affected by it.
Yeah.
And seeing someone who cares, who physically cares for you being attacked, it threatens your own safety.
Yes.
Children need safety and security.
Yes.
And it is lamentable when it happens, but it can be necessary to raise this as an issue in the family court. And in those cases where the children are at real risk, that you can go to the family court, but also to the district court, also to the high court for protective orders.
Okay.
So there's a special ordinance called the Domestic Violence Ordinance.
Yes.
It's a longer name, but it's the Domestic Violence Ordinance.
Yeah.
And there's also wardship, these two modes of application to seek orders to protect children or protect parties. Now, under the Domestic Violence Ordinance, there are a few different orders, and I put them there that can be obtained.
Okay.
One of them is an order, a non-molestation order.
Okay.
So it's like an order you can no longer do what we call molestation. Now that doesn't necessarily mean what you immediately think it means. It's really any kind of disturbing, harassing, hitting, assaulting, all these kinds of things put together. I've kind of described it there. The second thing is, and you can imagine why, if parties are living in the same home, sometimes it's necessary to get an ouster order. So a requirement that person leave the home. The third kind is where you are allowed to re-enter work or home or any place part of your life for the same reason. One person has left because of the violence and they need to come back, and the other person needs to leave. The fourth thing is counseling. The court can, after going through this process, order that one of the parties do counseling. Now, it's a bit of a hit and miss with whether or not that really affects changes, but sometimes it can, in the long term, improve relationships. And finally, in the event that somebody disobeys the order, the court can provide what's called authorization of arrest.
Okay.
So allow a police officer, if they think there's a reasonable cause to believe that somebody has breached the order, to arrest them on the spot without a warrant.
It sounds very intimidating, but but our experience that sometimes the police do not want to get involved in domestic violence.
Yes, it's very unfortunate, and Hong Kong has had a bit of a sad history. You may remember there was a judicial inquiry a few years ago, 10, 15 years ago, where a woman who'd been abused and beaten came into the police station and said that the husband was threatening violence against her. And the police turned away. They didn't even write down the report, and she went home, and she was killed, and the children were killed.
Oh,
this was a very famous case in Hong Kong.
Now that I remember.
So it is unfortunate, but it does happen in Hong Kong. Now, I would say that really it's the kind of thing where if you can get advice, you should. If you can't, then you should consider going to legal aid and applying. You can get if you're the weaker financial party, then you should go to legal aid and get a legal aid assignment, which can be done very quickly in domestic violence cases. Again, unfortunately, the bureaucracy, whether it's legal aid or the police, sometimes they view this domestic incidents, they view it down here, it's not a high priority for them. So you do need someone on your side. I can certainly say that there are a number of domestic violence specific NGOs, social welfare organizations in Hong Kong. That would be my other suggestion. Solicitors I know, like yourself, often encourage clients to go and seek that kind of assistance, because you need an advocate on your side, both at the legal level but also at the practical level.
Yeah, it's very necessary to immediate measures. Either to see a lawyer or social worker.
Social workers, the superheroes of Hong Kong.
Yes. Two sides, there are not really many of them. Too many of them. We need more of them.
We need more of them.
Yeah.
I totally agree.
Yes.
Fewer lawyers so we can increase our rates.
All right. How are we doing in terms of time, Alex? Is Alex around? Yes.
We're about 3 minutes before we hit 5 p.m. So I think it would be a good time to end.
Okay. Well, unless there are more questions from the people.
Did we get any questions? Let's see. Okay.
Well, we're in the time remaining.
Well, thank you to Azan and Alfred for this presentation on the legal aspects of child arrangements, as well as some practical tips in dealing with these disputes as well. Before we head to Q&A session, I'd like to take this opportunity to encourage everyone to open up the chat box and fill in our survey, because we'd really like to hear your feedback about today's presentation, and also about the types of topics you would like to hear about going forward. So yeah, does anyone have any questions at this point? Please feel free to turn on your microphone and ask your questions.
Usually this time is very exciting. Coming up with questions that we don't know how to answer.
Great.
Hopefully we do. Probably not.
Maybe not.
Good.
So I do have one from my end over here. So it's regarding the position of unmarried fathers. So as you've mentioned, the position of unmarried fathers goes both ways, in that they don't have automatic custodial rights to the children, nor do they have automatic obligation to provide maintenance for the child. So yeah, so like it goes both ways. But there seems to be a focus on marriage as an institution, as I see it, due to the arrangement. So do you think there would be room for development to the law so that these rights and responsibilities are attributed to the unmarried father, so long as they're the legitimate father of the child?
Go ahead. Yeah, well, there was a law reform proposal in the Children's Bill, Parental Responsibility Bill. I believe they discussed in the consultation making amendments to these, if you like, default rules. In the end, the bill itself has not been put forward for promulgation by the LegCo anyway. The thing to remember is that this isn't a question of common law, so it's not as though the courts can simply develop it immediately. it's black letter law. It's an ordinance called the Guardianship of Minors Ordinance. So I would say that that kind of change requires legislative change. And at the moment, I think it's very unlikely that our political system is likely to support this kind of change.
I can only add that in the meantime, don't think that you can knock somebody up without taking any responsibility.
No, that's true, yeah.
It sounds a bit unfair that you have to apply for guardianship in order to have rights, but then at the same time, the court seems to be emphasizing on the sanctity of marriage is either yes or no.
Mm-hmm.
So there's no common law marriage, de facto marriage, and these are all recognized in the other jurisdictions like Australia and Canada, not in Hong Kong.
Not in Hong Kong, no.
Even in the UK, now that they're saying that common law marriage seems to be having a little bit of space. In terms of, especially when talk about immigration, for example.
Well, they had the Children's Act in 1989, and unfortunately, Hong Kong has not followed suit in having a wholesale review of the law. I would just say this: I've thought long and hard about why this rule is there, and the truth is that the previous common law rule, the older rule, was that neither parent had any rights or responsibilities towards the child.
An illegitimate child.
Yeah, an illegitimate, the child born out of wedlock.
Yeah.
And the reason for that was the idea that really was focus on marriage before. And they reformed that because it's not in the child's interest not to have parents. Now, the reason why the rule right now, if you like, the good justification for it is that it's not always immediately obvious who the father is. It's not as though every child has a blood test, a DNA test at birth, and the fathers are readily identifiable. So most of the time, the law has to have a default that's workable.
Okay.
And so when a mother bears a child, it's obvious who bears the child.
Yeah.
The child came out of the mother. So that's kind of, if you like, the immediate answer that, okay, this connection between these two people is known. So the law should recognize that and have rules to support it. Now, the only thing I'll add to that is that unmarried fathers should know that the law is not against them, and they can apply, and they will be treated the same as married fathers. The only requirement is that they apply.
Yep. Yeah. All right, thank you. We have another audience submitted question over here. So the question is whether a couple who are not in divorce proceedings, can they apply for non-removal orders as well?
Yes, if a couple, so that is entirely possible. It's perfectly possible to go to the court. In the case of an emergency, you can go to the High Court and apply in wardship. The moment that you apply, then, and if you communicate it to the immigration department, then you can get the child. The child should not be removed from the jurisdiction without the permission of the court. So it is possible, but as I say, it really you have to go through. You have to tick all the boxes and get it done quickly.
And if it's necessary to take such drastic measures, you to protect your children against your spouse doing something, I believe divorce is
maybe on the cards.
Yes.
Although I say that sometimes people go through difficult moments and their relationships are salvaged. And I would say that if somebody is concerned about that, it's not the end of the relationship to apply. Sometimes the end of the relationship has happened and it's just a question of applying, but I would say that shouldn't be a reason that you don't apply.
No problem. Yes. Okay.
All right, thank you, Azan and Alfred. Well, these are all the questions from my end. Does anyone from the audience have a question they'd like to ask directly?
No problem.
I believe not. So, well, in that case, thank you, Azan and Alfred, again for your time today. And thank you, everyone, for joining our knowledge sharing session for today. So just as a final reminder, please feel free to fill out the survey in the chat box. And please, everyone, take care in these desperate times and have a good day. Thank you.